Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة. أسعد الله أوقاتكم بالخير مستمعينا في كل مكان، تحية طيبة لكم، ونقدم لكم الآن حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز على الهواء مباشرة. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023 للمشاركة على الهواء، وأيضا بإمكانكم المشاركة عن طريق الواتساب برسائل صوتية أو نصية، والرقم هو 313-327-7074. أيضا بإمكانكم الحصول على استشارات مجانية في الاختصاصات التي يتعامل معها مكتب المحامية جومانا كيروز، وهي قضاء الإصابات الشخصية من ضمن حوادث السيارات، إصابات العمل والأخطاء الطبية، قضاء الهجرة والتجنس، قضاء الإفلاس، قضاء الضمان الاجتماعي، وقوانين العائلة. ورقم المكتب هو 248-557-3645. تحياتنا لكم. جمانة، مساء الخير.
مساء الخير رامي، يعطيك ألف عافية.
الله يعافيك. تحياتنا لك جمانة.
تحياتي لك وتحياتي لكل المستمعين وتحياتي لضيفنا لليوم مثل كل نهار خميس المحامي باتريك هوران. اختصاصي لتقريبا 22 سنة بقضايا الضمان الاجتماعي SSI SSD وبالإضافة بالإصابات ضمن العمل اللي بيسموها بالإنجليزي Workman's Compensation. رامي، هل صوتي واطي عالي ولا جيد هيك؟
ممتاز، نسمعك بوضوح تام جمانة.
Very good. Good afternoon, Attorney Patrick Horan. How are you today?
I am doing great, Joumana. How about you?
I am doing very well. We are going through some gorgeous days, aren't we?
It's, there's not going to be many of them left. We need to take advantage of them for sure.
Indeed. Happy to have you. Thank you for being with us every Thursday to answer our questions regarding SSI, SSD, and Workman's Compensation. I want to remind the listeners that they can send us a question if they don't want to call on the radio WhatsApp number, and that number is 313-769-6666. And they also can call us at 313, I'm sorry, the number to call is 313-769-6666, but the radio WhatsApp number is 313-327-7074. My apologies. لأي شخص بحب يتصل عنده سؤال على الوركمانز كومب كيس تبعه أو عنده سؤال على الأساساي فايل تبعه. طبعا مش إذا كان موكل، لأنه ما فينا نحكي عن ملفات موكلين قدام الآخرين، بس سؤال عام is fine، أو أشخاص بيحبوا يسألوا يمكن ملفاتهم مع محاميين آخرين. اليوم أكتر شيء رح نحكي عن workman's compensation إلا إذا إجينا أسئلة بموضوع السوشيال سيكيورتي. بس قبل ما نبلش بدي أرجع أذكر المستمعين إنه بعتذر in social security للأشخاص اللي بدهم يقدموا، نحن ما فينا نقدم عنهم، ما فينا نقدم بالنيابة عنهم، لازم هم يقدموا ويعطونا الفايل نمبر، وهون المحامي بات هوران بيقدر يعمل appearance ويعلن إنه هو المحامي على الملف and we can take it from there. وفي أشخاص بيقولوا لنا إنه العربية الإنجليزية تبعهم على قدهم أو منا جيدة. حكينا بالماضي بنرجع منذكر لأنه إجاني هذا السؤال هالجمعة كمان مرة. منذكر إنه الشخص اللي بده يقدم على SSI والإنجليزية تبعه مش جيدة بيقدر يطلب من السوشيال سيكيورتي أدمنستريشن مترجم ترانسليتر محلف بتأمنه السوشيال سيكيورتي أدمنستريشن for free without a charge للموكل أو للشخص اللي عم بيقدم. فبيتصل الشخص بالSSA Social Security Administration بيقول لهم انه هو غير قادر من انه يتكلم يعمل، لانه في عدة طرق الإنسان بيقدر يقدم على Social Security SSI. بيقدر يكون in person، بس ال Social Security Administration Offices مسكرين حاليا. بيقدر باي فون أو بيقدر on the computer. فللشخص اللي بده يعملها باي فون وبحاجة لمترجم، ما له غير يتصل بالسوشيال سيكوريتي ادمنستريشن يبلغهم انه بده يقدم على SSI، بس بده شخص يترجم له من الانجليزي للعربي، من العربي للانجليزي. وهون السوشيال سيكوريتي ادمنستريشن ترجع بتأمن له مترجم، ترجع بتتصل فيه من جديد. فاللي بيهمه الامر كان كول at 1-800-772-1213. كمان مرة the toll free number للسوشيال سيكوريتي ادمنستريشن هو 1-800-772-1213. You let them know that your English is very limited. They will find you an Arabic translator and call you back. They will not provide you with one at the moment you call, but they will call you back, and you can then fill out the application over the phone with someone helping you. You get the claim number or the file number. You call us back with it, and then attorney Patrick Horan can now file an appearance and be the attorney of record for you. I just wanted to clarify this before we go any further in today's discussion. The first thing I wanted to talk about today, we're going to talk a little bit about work-related injuries, what we also call workman's compensation. Attorney Patrick Horan, can you tell us how are lawyers paid in workman's compensation cases? Because I can tell you how lawyers are paid in car accidents. You know, you make you get the settlement, and then you return to the lawyer the cost that the lawyer has spent in the case, and whatever is left, you divide that by law, by statute, 1/3 to the attorney, 2/3 to the client, except if it is a case against somebody's insurance company, that 2/3 may be shared between you and other doctors so that those doctors can get paid and not sue you personally. Is it the same way in a work-related injury, in a workman's compensation? Does the lawyer also charge 1/3?
No, Joumana, we do not. So workers' compensation fees are set by the statute, by the workers' compensation law. And so every lawyer in the state is going to show you the same figures for our fees. And the fee is a sliding scale depending on what we have to do to get a recovery for the client. Now, the important thing to remember from the get-go is you don't owe an attorney a fee unless there is a recovery. So you're never going to sit down and write a check to a workers' comp attorney for him to represent you. Okay? The fee always comes out of the recovery.
In that case, it's exactly similar to someone hiring a car accident attorney, no recovery unless we win, including the cost on a case. We absorb that if we don't win for the client.
That's right. Now, in our case, in workers' compensation, we advance the money for costs, and then the costs come out before our percentage is figured for a fee. Now,
okay, and that too is exactly like in a car accident.
Great. Now, here's where the big difference happens, though. You just mentioned a 1/3 fee, and I would love to see that, but that doesn't happen in workers' comp. In most workers' compensation cases, the case settles, and if the case settles, our fee is either 15% of the first $25,000 and 10% of anything beyond that number, or a straight 10% fee if the case is not in dispute. That's a settlement. So you can see we're getting a lot lower percentage, and the injured worker is getting more money out of the settlement.
Okay, so if the case settles for $40,000, you make 15% of the first $25,000, and you make 10% of the remaining $15,000.
That's exactly right, Joumana. And as soon as you started using numbers, I was afraid you're going to hit me with a math question on here.
No. I made it simple for you today. Now, if the case is not in dispute, then your fee is even less than that. Your
Right.
attorney fee is 10%.
That's right. And you're going to see as we go through a workers' compensation fee agreement that the fee changes based on the complexity of the case. So when a case is being paid and there's nothing in dispute and we negotiate a lump sum settlement for the client, that's generally less work involved than going to trial or preparing a case for trial that's in dispute.
Okay. Now, cases that end up going to trial, I know they are far and in between, especially in workman's compensation. But assume a case goes to trial, what will be the attorney fee in that case?
In that case, we get very close to your 1/3 fee. It's a 30%.
You get 30%.
That's right.
Okay, we get 33.33%.
Yes. So I lose that extra 3, but we work just as hard in workers' comp because we have to take medical testimony and lay testimony just like you do in an auto case.
Absolutely. So أول نقطة عم نحكي عنها اليوم هي شو بيشرج محامي الوركمنز كومبنسيشن، محامي الإصابة ضمن العمل. مثل مكاتب المحاماة لحوادث السيارات، الدفع بعض التحصيل فقط إذا صار تحصيل. يعني لنقول مكتب محاماة مثل مكتبي أو بات أخذ ملف إن كان إصابات ضمن العمل أو أخذت أنا ملف حادث سيارة، إذا ما ربحنا هذا الملف ومن وقت لآخر بنخسر ملفات عنا نحن أوقات لأنه بيكون في surveillance، لأنه بيكون في fraud، يمكن on emotion for some redisposition. It happens, it rarely happens, but it does happen every once in a while. So هؤلاء الملفات دائما القانون هو ذاته بحوادث السيارات وبالworkman's compensation we do not no recovery unless you win. ما بناخد منك كمكتب محاماة شيء إلا إذا ربحنا لك شيء. السؤال هو طيب إذا المكتب المحاماة صرف مصاري من جيبته، قدم الطلب بالمحكمة، أخذ ملفات medical records، أخذ إفادة دكتور إلى آخره. كمان مرة مكتب المحاماة بيمتص هيدول التكاليف إذا الملف طلع خسران. العقود اللي مكاتب المحاميين بيمضوهم للموكلين بفندوا بطريقة كتير واضحة هيدا الشيء لحتى الإنسان يكون مرتاح نفسياً إنه اللي عم بيقول له إياه المحامي هو مزبوط وهو مكتوب كتابياً. والقانون كمان بيقول إنه أي عقد بين محامي موكل for a personal injury case must be in writing. يعني أنا ما فيني مثل موكل مش مضيته على عقد، بس أنا فيني مثل موكل مش مديته على عقد إذا كان طلبني بمثلا قصة طلاق. But in a personal injury case it has to be in writing. Now بحوادث السيارات دائما تكاليف المحامي by law بعتذر تكاليف الملف by law إن كان بحوادث سيارات ولا إن كان بإصابات ضمن العمل، القانون هو ذاته بيقول إنه من بعد ما يصير في تسوية أول شغلة مكتب المحاماة بحق له ياخدها هي يرد التكاليف اللي دفعها المكتب من جيبته ليمشي القضية. لأنه مكتب المحاماة ما بيجي عند الموكل بيقول له ادفع لي الفايلينج فيه لروح أقدم الفايل، ادفع لي البوليس ريبورت لأطلب البوليس ريبورت. بيسلف بيقولوا advance the cost، بيسلف هالأشياء كلها وبينتظر لنهاية الملف لحتى يربح، ساعتها بيرد هيدول التكاليف. هيك القانون بيقول. لنقول إنسان أخذ 100,000 وتكاليفه طلعت $1,000، منرد التكاليف $1,000. هلأ صارت التسوية $99,000. $99,000 بحادث سيارة. التكاليف المحامي للمحامي هو الثلث اللي هي 33.33%. ما تبقى هو للموكل إذا كانت التسوية عطل وضرر، وهي للموكل والدكاترة تبعه إذا كانت التسوية ضد الإنشورنس تبع الكمباني تبع هذا الموكل. لأنه بلا أتعاب المحامي في كتير دكاترة ما رح يقدروا يحصلوا مصرياتهم، فأكيد التسوية كانت أعلى لأنه زدنا فيها هيدا الدكتور، هيدا الفيزيكال ثيرابي إلى آخره. بحق له المحامي إنه ياخد الثلث، وإنما الثلثين مش كله لصاحب الشأن حسب نوعية الكيس. مثل حوادث السيارات no recovery unless we win. مثل حوادث السيارات بناخد تكاليف اللي دفعناها من اجرتنا out of pocket expenses قبل ما نعطي الموكل حقه. هلا قد ايه الموكل بياخد بتختلف اذا كان حادث سياره ولا اذا كان workman's compensation. مثل ما قلنا حادث سياره it's 33.33% للمحامي 67.67% للموكل. اما بالworkman's compensation اذا الكيس صار عنده تسويه والتسويه جابت اول $25,000 15% بيروح للمحامي 85% بيروح للموكل. إذا كانت التسوية فوق 15% ساعتها أول 25,000 بعتذر، إذا كانت التسوية أكثر من 25,000 بعتذر، أول 25,000 المحامي بيشرج عليها 15%، الموكل بياخد 85%، والمبلغ اللي بيتعدى ال 25,000 المحامي بياخد فقط 10% والموكل بياخد 90%. أما إذا كان الملف عمل تسوية بلا ما يكون في ديسبيوت عليه ساعتها تكاليف المحامي هي فقط 10% والموكل بياخد 90%. أما إذا الكيس، وهو من النوادر انه الكيسز بالوركمنز كومبنسيشن روحوا على الترايل، اما اذا الكيس راح على الترايل ساعتها المحامي بتعلى لانه الجهد عليه بيعلى، المحامي تكاليفه بتعلى، بيصير شوي قريب لمحامي حوادث السيارات بس مش 100%. محامي حوادث السيارات دائما بياخد 33.33%، محامي الوركمنز كومبنسيشن ان كيس اوف ترايل بياخد مش 33.33%، بياخد 30% اللي هو شوي أقل. يعني تكاليف المحامي قليلة بworkman's compensation، أقل بكتير من حوادث السيارات. وكمان مرة نحن قلنا بالسابق، يمكن اليوم نحن ما عم نردد معلومات جديدة، ما عم نقول معلومات جديدة قد ما اليوم الفوكس رح يكون نردد معلومات حكيناها مرة أو مرتين قبل بس مش كافي. رح نقارن تكاليف المحامي بالوركمنز كومبنسيشن والكار اكسيدنت مع السوشيال سيكيورتي اللي هي برضو أقل بكتير من بعد ما ناخد فاصل سريع. Attorney Patrick Horan, since we talked about attorney fees in workman's compensation and we compared them with attorney fees in car accidents, let's also quickly go over after this quick ad attorney fees in social security cases after this quick break.
مكتب المحامية جومانا كيروز يبحث عن موظفين يتحدثون العربية والإنجليزية بطلاقة، ويفضل أن يكون للمتقدم خبرة في العمل المكتبي. هذه الوظيفة بدوام كامل من الاثنين وحتى الجمعة من الساعة 9 صباحا ولغاية 5 مساء. تقدم الوظيفة العديد من المزايا ومنها التأمين الصحي وإجازات مدفوعة وغيرها، ويقرر الدفع اعتمادا على سنين الخبرة. فمن يرغب بشغل هذه الوظيفة الاتصال بمكتب المحامية جومانا كيروز على الرقم 248-557-3645. مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات. قبل أن تختار المحامي الذي سيدافع عن قضيتك دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز.
نرجع بهالنهار الجميل مع المحامي باتريك هوران، اختصاصي في مكتبنا في قضايا السوشيال سيكيورتي SSI و SSD وفي قانون الوركمنز كومبنسيشن. كنا عم نحكي عن تكاليف المحامي اني وركمنز كومبنسيشن كيس، وفرجينا كيف هي اقل بكتير كتير كتير من حوادث السيارات. رح نحكي بطريقه سريعه عن تكاليف المحامي ان سوشيال سيكيورتي اللي هي اقل بكتير من الوركمنز كومبنسيشن. رح نسال المحامي باتريك شو تكاليف المحامي in an SSI case بالأول. Attorney Patrick Horan, can you tell me what is the most money as a lawyer you can ever make in an SSI case? $6,000?
Yes, Joumana. So I prepared for today's radio show, and I actually did some math so that you couldn't surprise me with this question. um, so the fee in a Social Security case is 25% of past due benefits up to a maximum of $6,000. That means
I'm sorry, say that again. 25% of what?
Of past due benefits, or we call that the accrued. Okay, so if your Social Security benefit is $1,500 a month, and you win the case and you are owed 3 years of past benefits, there will be a lump of money there called the accrued, right?
Mm-hmm.
Now, so my fee is 25% of that amount up to a maximum of $6,000. And that means if there's $40,000 in past due benefits, my fee is not $10,000, which would be 25%, but still only limited to $6,000.
Okay. So
You see
even
how
if
I
you
did the
recover,
math there?
yes, yes, very good, very good, very good. However, if you recovered $4,000 for someone in past due SSI, then you are making $1,000. You're making 25% of the $4,000, which is $1,000. But if the money is more and more and more, it is capped. You cannot keep applying the 25%. The most you can ever make in a case that the past accrued benefits are, a lot, is $6,000. So
Yeah.
the maximum value. So here we have cases in this office, millions of dollars in car accidents, semi trucks, sadly, and stuff like that, commercial policies. And the maximum you can make in a Social Security case is $6,000.
Now there is a very narrow exception to that, and that's if a case is denied by the Social Security judge and we appeal it beyond the hearing level. In that case, we can exceed $6,000, but we're still capped at 25%. Because sometimes cases that get appealed beyond the hearing level, it takes much longer for the hearings for the appeals to run out.
Okay, so if you appeal a case, there is no more maximum of $6,000 because it's almost like a trial. So you are entitled to 25% of what you recover.
Correct.
Okay. By the way, I was making the distinction between, the car accident cases and your cases, just to show a little bit of comparison, but you're extremely successful and you have thousands of clients who put their trust in you in Social Security. So that $6,000 can be hundreds and hundreds and hundreds of thousands of dollars in attorney fees because you're very successful.
Well, thank you very much. I will point out that what we've talked about today with attorney fees, you see the limits on disability cases. As a practical matter, that does mean that we need to have a lot of clients.
Yes.
And so we do have to work very hard to keep up the communications with the clients.
Absolutely. Thank you very much for clarifying today. So the attorney fees and workman's comp and SSI. So كمان مرة حكينا عنه بالماضي. أكبر ملف للSSI في أي مكتب في ولاية ميشيغان على الأقل بيطلع فيه المحامي لحد $6,000 فقط عليها كاب. للإنسان اللي بيقدم SSI لموكله والسوشيال سيكيورتي ادمنستريشن بتقتنع إنه هيدا الإنسان صار له معاق 2 و3 وبدها تعد المصاري من 2 و3 لحد اليوم، المبلغ رح يطلع كبير لأنه شهر ورا شهر سنة ورا سنة. المحامي اللي بيمثله بياخد 25%، بس هاي 25% بتوقف أول ما يوصل $6,000. للإنسان اللي بنحصل له 40 و50 ألف، هذا الشخص فقط بيدفع لنا $6,000 فقط. By the way, Pat, does the Social Security Administration send 2 separate checks, one for the client to your office and one for your attorney fee, or does it come in one check that you separate?
Yeah, that's I meant to bring this up before when we were speaking about workers' comp fees, because whenever there's a settlement in workers' comp, the insurance company sends out a check to me for my fee and costs and a fee directly to the client for their remainder. So there's the meeting you described at your office where you're splitting the amount between you and the client doesn't happen. The check is sent directly to my client. Now,
okay. And when you say cost, mm-hmm. Do you mean cost and attorney fees, or do you mean cost only?
So in a workers' compensation settlement, If my fee is $5,000 and I spent $500 preparing the case, I'll get a check from the insurance company for $5,500, and I'll pay the costs. My client gets the balance, and I'll get the $5,000 fee. Does that make sense?
Okay, that makes sense. So, and your attorney fee, does that also come from the Workman's Compensation Bureau or the Workman's Compensation Insurance Company, or is that split between you and the client?
From the insurance company. So, in other words, in workers' comp settlements and in Social Security, we don't need a meeting to release the fee to the client. The client is sent directly their check from either Social Security or from the workers' comp insurance company, and I receive my fee separately.
Okay. Do you receive two checks in workman's compensation, one for costs and one for attorney fees, or is it one check for both?
It's one check for both, and then I have to split it out.
Now, in Social Security, you also said that your attorney fee is sent to you separately from the Social Security applicants portion?
That's correct. In fact, it's directly deposited into my firm account.
It's directly deposited. You don't even get a check.
That's right.
Okay, thank you very much. I want to remind the listeners that like every Thursday, we talk with Attorney Patrick Horan regarding SSI, SSD, and regarding workman's compensation. Before we move on, SSD, every time I asked about attorney fees and SSD, I got a very complicated answer. How do you charge? What is the attorney fee for somebody applying for SSD and getting approved?
The attorney fee in Social Security is 25% of past due benefits up to a maximum of $6,000.
That's for SSI and SSD?
That's correct.
Oh, I did not know that. So SSD and SSI, the attorney fee is the same, 25% up to $6,000.
I use the exact same fee agreement. The contract I sign with the client is the same no matter, because Joumana, most people have applied for both when they apply for disability benefits at Social Security. They don't even maybe know which benefit they might be entitled to at the time that I meet them.
And you also said in the past that if somebody applies for SSD only and they're totally wrong, the Social Security Administration will look at it as an SSI case and see if they qualify for SSI, correct?
That's right. Ordinarily, the person taking the application will treat it as an application for both benefits. And I have had a few cases where that gets overlooked. And when we get to the hearing level, the judge will go ahead and take that amendment at the time of the hearing.
Okay, very good. Thank you so much. We talked once, maybe twice, about the fact that people who get injured on the job and unfortunately have to treat and stay out of work, if they knew the law, they would know that they're not going to make money in a workman's compensation case. They're not going to be made whole in a workman's compensation case, because the way the law is written in a workman's compensation case, you do not get compensated for 100% of what you lost. Let's say you were out of work for 3 years and you lost $100,000 or $150,000 for 3 years of wages. They're not going to pay you $150,000, correct?
That's right. You only get 80% of your after tax up to a maximum amount every week.
Right. And then that money may be even further. Forget that the attorney will charge, 15% of the first 25,000 and then 10%. So you never get 100% anyhow. But that number may be also reduced if Medicare has paid part of your bills, private health insurance has paid part of your bills. Can you elaborate on that a little bit?
Yeah, sure, Joumana. There are certain statutory liens in a workers' comp case, and that means that they have to be paid out of any workers' comp settlement. The three statutory liens are friend of the court. So if you have a divorce decree and a friend of the court arrearage where you owe money for child support, That money has to be paid before you get any money out of your workers' comp settlement. So friend of the court is the first statutory lien. The next one is Medicaid. If you have had medical treatment for your work injury paid through a Medicaid or Medicaid HMO plan, which are very common now, those benefits have to be repaid out of your workers' compensation settlement. And the last one is Medicare. And Medicare benefits, if you've gotten medical treatment through the Medicare system, then not only do they have to be repaid for past treatment, but if the settlement is more than $25,000, Medicare will want a set aside for future treatment.
Okay, so can you walk us through a quick example for that?
Sure. Let's say a case settles for $50,000 and in a workers' compensation case. And the individual, the injured worker, had a friend of the court case, and because he's been out of work, he's fallen behind, and he owes $5,000 in child support through the friend of the court system. One of the lines on the workers' comp settlement statement will be a repayment to friend of the court. They have to be repaid.
Okay.
If he has had treatment with his Medicaid HMO, one of the many different Medicaid HMOs in the state, they have a subrogation department, and that's a big word that means they get repaid, right? So there'll be a line on the workers' comp settlement that'll repay his Medicaid treatment. And if while he was disabled, he got on Social Security disability and became eligible for Medicare, or if he was over age 65 and had Medicare, now Medicare is going to want conditional payments repaid for treatment in the past, and they're going to want to evaluate the claim to see how much, if anything, should be set aside for future treatment so that the government is not paying what should be his employer's responsibility.
Okay, what should be his employer's responsibility? So when you have someone who has Medicare and you said that it's 80% of net, when you add the Medicare for what they paid up to today and what they're going to set aside moving to the future, sometimes this 80% goes down to 40%.
Well, right, but when I'm negotiating on my client's behalf, I'm taking all that into account. So if we're negotiating a settlement, I want the employer to fund that Medicare set aside or to pay the Medicare out of pocket if, in fact, it's work-related treatment.
And how do you do that?
Well, if the injured worker injured his back and he went to the doctor and the doctor treated his back and the doctor's bills were paid by Medicare, Medicare will show that treatment was, and I'll submit it to the employer when we try to settle the case and inform the employer that he not only needs to settle wage loss, but he needs to reimburse Medicare as well.
And how often are you successful when they don't have to do that? How often would you find an employer successful to be willing to foot that?
It depends on every case, Joumana, because first and foremost, we have to show that the condition was work-related. And if we show it's work-related, then the case obviously has good value. And the defense attorney, the attorney who's representing the insurance company or the employer, he has to or she has to point out to their client the liability that they face if they lose the case at trial.
Okay. So how many people are surprised when you get them their settlement in a workman's compensation, and here they're thinking, I've been out of work for 3 years, I made $40,000 every year, and you're getting me $40,000. Had I continued working, I would have made $120,000, paid taxes on it, and still kept $90,000, which is a lot more, let's say, depending on the tax bracket, which is a lot more than the $40,000 you're bringing me. How many people are surprised on the day of, the settlement?
Well, I try to minimize that because when I first meet with a client, I have a discussion about what they should expect in a workers' compensation claim. And the phrase I always use is, we don't get to do a touchdown dance at the end of a workers' comp case.
What does that mean? What does a touchdown dance mean?
What I mean by that, Joumana, is when we win the case, the client is losing money compared to what they would have made had they not been injured. I'm never getting them more than they could have won. So we can't celebrate too much winning a case because they're disabled and losing money for their family.
Correct, because let's remind the listeners that in a workman's compensation, you can never sue anyone. You cannot sue your employer for pain and suffering. You cannot do that. In workman's compensation, it's just a question of math. It's your medical bills, it's your wages, capped at a certain amount by the workman's compensation schedule, and you add line item 1 and line item 2, and there is your settlement. You don't pad that recovery by adding an extra recovery for against your employer or somebody else for your pain and suffering. That happens in a car accident. That happens in a general negligence claim. But that does not happen when you have a work-related injury. Why? Because that's how the law is written. Simply because that's how the law is written. Why is the law written like that? Because it's against public policy. They said it's bad public policy if every time you are injured during the job, you go sue your employer, because your employers will go out of business. It's not good for society. It's not good for the economy. So the law is written, and I want your input on that, in such a way that you cannot sue your employer for your physical pain and mental suffering because it is against public policy. Your thoughts?
Yes, it was a compromise that was negotiated a long time ago. And the compromise limits your recovery, but spreads it out so that even workers who are negligent themselves can still get compensation. And I think that's
even if the employee caused his own injury, should have known better or whatever it is, she or he can still get workman's compensation.
That's right. And anybody in any workplace sees this all the time. People are negligent, they don't pay attention, and they hurt themselves.
And even if your employer caused you the injury, you still cannot sue your employer for your pain and suffering.
It is a no-fault system. That's exactly right.
Even if it was a totally avoidable injury on the part of the employee or on the part of the employer, it's not a bar to making a workers' compensation claim. What you give up, though, is your right to sue your employer even when your injury is the result of her or his negligence.
That's a great way to put it.
Is it any different in any of the other 49 states, to your knowledge?
You know, I do know that some states are different in the way that they handle. And I'll say this: it is a state-by-state system. I'm licensed to practice in the state of Michigan, so I don't handle workers' comp cases in other states. I did take a call, I bet 15 years ago, from a state, I want to say it was Maine, who had questions about our system because I believe they were revamping theirs and wanted to model it on our system. Michigan system is held up, I think, as a model nationwide.
Okay. Pat, we're going to take a quick break. And when we come back, I want to talk about something you mentioned on the radio so far only one time. Some people are very concerned to make a workman's compensation claim because they're concerned that their employer will take it out on them. It's called retaliation. You talked about if someone loses their job within 2 years of returning to work following a workman's compensation, there is what we call a presumption, and it's only a presumption of retaliation if somebody loses their job within 2 years of returning from a workman's compensation case.
That's right.
كاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات قبل أن تختار المحامي الذي سيدافع عن قضيته. دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز.
وبنرجع مع المحامي باتريك هوران. بعتذر رامي، am I on؟
نعم جومانا، أنت على الهواء.
نرجع مع المحامي باتريك هوران، وبعد عنا قديش رامي؟
فاضل شيء تقريبا 15 دقيقة.
اوكي فيري جود. سو بنرجع مع المحامي باتريك هوران وبدنا نحكي عن شغله حكينا عنها مره ومرقنا عليها مرور الكرام، من الضروري نرجع نتكلم عنها اليوم واكثر من اليوم ومن بعد اليوم. انه في اشخاص كثير بيعتلوا هم اذا صار عندهم اصابه ضمن العمل وعملوا workman's compensation claim، انه وقت اللي بدهم يرجعوا اذا رجعوا وقت اللي بدهم يرجعوا رب العمل بده ياخذ بطاره ضدهم لانه قدموا كليم ضده. والمحامي باتريك هوران بلغنا انه في شيء بالقانون بيقول انه اي انسان بيخسر شغله ضمن 2 من رجوعه على العمل من بعد اصابه ضمن العمل، عم نحكي فقط اصابه ضمن العمل. اي انسان بيخسر شغله ضمن 2 من رجوعه للعمل من بعد اصابه ضمن العمل، في شيء بيسموه بالقانون presumption of retaliation، يعني يعتبر انه رب العمل اخذ بطاره، والريتاليشن هي illegal، هي ضد القانون. you cannot retaliate، ما فيك تقاصص موظف لانه عمل كليم بحق له قانونيا يعملها، ما فيك تقاصصه وتطرده. بيسموها presumption، يعني مبين كأنه يعني في علامة استفهام انه ظاهر انه رب العمل طير الموظف لانه هذا الموظف قدم workman's compensation claim. but رب العمل بيقدر يدافع عن نفسه ويفرجي براهين انه هو ما طيره ضمن 2 لانه wants to retaliate، ما طيره ضمن 2 لانه بده ياخذ بطاره لانه هذا الموظف عمل كليم، بس يمكن لانه هذا الموظف شغله كتير عاطل، يمكن لانه هذا الموظف is not listening to authority، يعني لأسباب وجيهة. So في شيء بيسموه بالإنجليزي presumption of retaliation, but that presumption can be overcome with adequate proof من قبل رب العمل. فبنسأل المحامي باتريك هوران. Before I ask you the question, how is a presumption, a presumption is you don't question a presumption, you overturn a presumption, or what do you do exactly with a presumption?
So a presumption legally can be rebutted.
You rebut a presumption. Okay, thank you.
That's right.
Okay.
And honestly, in situations like this where my client is retaliated upon and discharged from his job, I then refer them to an employment attorney to file a lawsuit in circuit court. So this is not a case that I handle, but I know I send them out to attorneys who are grateful to have this referral because these cases are generally winnable.
And you said before that people end up making more money in a wrongful termination. That's what we call it, a wrongful termination case. You send the case like that. Somebody comes to you and it starts like, I have a workman's compensation case, but it turns out to be a wrongful termination case. Or maybe it's both. Wrongful termination, why? Because somebody attempted to return to work, either part-time or full-time, and has been let go within 2 years of her or his return. So on the face of it, it looks like retaliation, but we don't really know. That's why we call it a presumption. And we call it a presumption simply because the law calls it a presumption of retaliation. However, a presumption can always be rebutted with adequate proof. So when you send the client to a wrongful termination attorney, if the attorney decides that it's a good case, now the employer can put forward proof that the reason why this employee was terminated is a legitimate reason, has nothing to do with retaliation, but it is because they are performing very bad on the job. Maybe because they're not, performing the essential functions of their job, as you said before. So there could be good and valid and legitimate reasons why an employer terminates someone within 2 years of returning to a job outside of retaliation.
Absolutely. And a smart employer will make a good record. We call it fly specking, but they will start to make notes of things that the employee does wrong so that they've got a good reason to let them go, even if in fact their real reason is terminating them because they made a workers' comp claim.
Okay. So they, um, a good employer will start making a record, and that record will show upon litigation, or should assist the attorney to show upon litigation that the reasons were poor performance, poor attendance, all kinds of things that an employer has the right to document and ultimately let an employee go for. I mean, after all, we live in a no fault state. That means an employer can let you go for any reason, even if he does not like the color of your new hair today, as long as that employer is not discriminating against you for your race and gender and political affiliation and religion, or is not retaliating, or not violating the Americans with Disability Act. But if your employer isn't doing any of those, but you're doing enough, or reason or no reason, but I would think that a smart employer upon somebody's return should really document it to show that the person is being let go for good cause, not just for the color of his hair.
Right. And so I guess the bottom line here is that once you make a workers' compensation claim, you actually have more protections, because now they do need to come up with good cause to terminate you. Whereas before that, they could terminate you because they want to hire their nephew. There's no other protections in Michigan unless you're in a union.
Let me make sure I understand. Are you saying in the law of workers' compensation, once somebody returns, they can only be terminated for good cause? The no fault law does not apply to a returning workers' compensation person?
I probably went too far with that, but we've talked about a presumption, and
Okay,
how do they rebut
a
the
smart
presumption?
employer would do that. Okay, got it.
Right.
But
And
technically, but
I want to
technically
be clear.
speaking,
Yeah, go ahead.
technically speaking, an employer can let go of someone within 2 years. Yes, will have to face a presumption simply because he does not like this person's hair anymore and wants to wants to hire his nephew. Technically, yes, but practically speaking, it's not smart, because that employer has a presumption of retaliation he or she has to overcome.
That's exactly right. And we've thrown the word smart around, and I think what we're really talking about is crafty, not smart, because you and I, Joumana, are the good guys in these cases. We represent the injured worker or an injured person, and an employer that's looking for a way to get rid of somebody because they had to make a workers' comp claim. That's not a good guy.
Absolutely. And let's also say that, when somebody makes a claim for workers' compensation, please know that an employer's workers' compensation premium isn't going to go through the roof. It isn't like car insurance. Workers' compensation insurance, depending on, what is it that you do for a living, generally is cheap.
Yeah, ordinarily workers' comp premiums for employers are figured on an industry-wide average.
Yes, like if you're working in a law firm, that's one thing that's way cheaper than if you are on the assembly line.
Yes.
Okay. So, yes, I mean, the they always say the law is really written in the hearts of people. If you want to be crafty and smart, quote unquote, and find ways to let somebody out simply because you don't like the fact that they filed a workman's compensation, you can find a way. That's why we say that the law is written, really, the true law is written in the hearts of people. And a good and ethical employer should not do that.
Right. But of course, if everybody was good enough, we wouldn't need laws, would we? We're getting deep today, Joumana.
We are getting deep today. We are. And today ended up being about workman's compensation. You've given us a lot of information today. Uh, Let me see, Rami, how much more time do we have?
Yes, we have
5 minutes.
yeah, exactly.
We have 5 minutes. So that's not enough to start any topic. But I just want to also, today we didn't share anything new. Maybe some of our listeners today heard something new, and we certainly hope that. And sometimes Repetition is so important. That's how you move things from short-term memory to long-term memory. That's what all the studies show. In order, we read so much, we listen to so much. And why is it that we remember so little? One of the reasons is because when you read or you listen to something one time, two times, three times, it may not be enough to move it from your short-term memory. See, we are getting deep, Pat. I'm now a psychologist. Short-term memory into long-term memory. Once you commit something to long-term memory, then that's it. It's part of who you are, and you will remember it, and you can call on it when you need it, and it will flash in your brain, but only if you've moved it from your short-term memory to your long-term memory. So that begs the question: how do you, when you learn something amazing, and what do you do? What do you have to do to move it from short-term memory to long-term memory? There is only one way that I know of, which is repetition, 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 repetition. So when we repeat information, not only do we have new listeners every time or different listeners, but we're helping people commit the knowledge, hopefully the information, and we try to share only helpful information to their long-term memory. Once it is in their long-term memory, it is part of who they are, and they can act on it, and they can put it to their good use. So with the 3 minutes remaining, I just wanted to say that sometimes somebody can be a 1099, and technically, if you are a true 1099, if you are a true independent contractor and you get injured, you don't have access to making a claim in workman's compensation because you're not an employee. Workman's compensation is only there for the benefit of a true employee. What determines a true employee is not whether somebody calls you that employee, not even the way you're being paid. Really, really, really distilled to its essence, what makes you a true employee, even if everybody calls you an independent contractor, including you calling yourself, including putting a writing together between you and the person you're working for or with, calling you an independent contractor, the more control someone has over you, the more control someone has over what you do and don't do, and when you come and where you work and so forth, the more you really are an independent, you really are an employee. And one thing that bears repeating, not today because we have 2 minutes remaining, but bears repeating in the future is, if you become a lucky person who is injured on the job because you really are a W-2 or because you're a 1099 who should have been a W-2, you'll be lucky because you have a workman's compensation insurance company that will pay your medical and at least some of your wages. The problem is, for those true independent contractors, say truck drivers, they don't have workman's compensation if they get injured. We pray to God that they have purchased, and those who are listening, purchase disability insurance. Disability insurance is very cheap. It will cover your medical and up to like 30, 40 weeks of, a portion of your wages. Without it, you are out of luck, and who's going to pay your medical? That's a big problem. Attorney Patrick Horan, thank you so very much for another amazing show.
Happy to
Rami,
be here.
Thank you. Rami, thank you very much. Tomorrow, bankruptcy with attorney Michael Bankstein.